Hi everyone, and thanks for joining us. My name's Kushall Amlani. Welcome to the final Dialogues and Debate session of MozFest 2023. We have big shoes to fill. For those of you who didn't catch the conversation that Bob had yesterday with the inspirational Angela Davis and Chris Smalls, I highly recommend you watch back. They talked about the impact of tech companies on society and the importance of communities and individuals. Today, we're going to take a slightly different angle and talk about the action of governments and lawmakers in the race to regulate tech companies. And we'll explore the question, how will regulations emanating from the EU and the US impact the rest of the world? Joining me on the panel is Marietje Schaake, International Policy Director at Stanford University Cyber Policy Center and International Policy Fellow at Stanford's Institute for Human-Centered AI. We also have Aisha P.L. Kadiri, PhD candidate at the École Normale Supérieure in Paris and Chair of Geopolitics of Risk. And last but not least, we have Nikhil Pahwa, entrepreneur, journalist, activist, and the founder and editor of Media Nama. Before we kick off, I want to mention one last thing. We're taking questions for this panel in real time. So if you're watching on the MozFest Plaza, on YouTube, or LinkedIn, you can use the chat function to add your questions. Alternatively, you can tweet them at Mozilla Festival with the hashtag Dialogues and Debates. Please get involved. So, panel, let's kick off. The challenges posed by large tech companies to consumers and to markets are well known and well documented, particularly in Europe and the US, where harms caused by online content or the concentrations of vast amounts of market power in a small handful of digital platforms. And laws are being introduced and lawsuits are being filed to challenge these outcomes. However, regulation follows the conduct of private actors, and often it's very far behind. So what is the impact of these tech giants in other parts of the world? And how does the race to regulate them impact beyond the borders of the EU and the US? So, Marietje, let's start with you. You were a member of the European Parliament for 10 years, and now you're a director in cyber policy at Stanford. So you're uniquely placed to talk about what Ernie Bradford labelled the Brussels effect. What do you think are the most impactful regulations coming out of Brussels at the moment? Let's set the groundwork for everyone.
Great. Well, thanks for having me. It's wonderful to join another MozFest, although not live this time. I think the impact of what the EU is trying to do can be seen in a variety of ways. I think, first of all, what is significant is that it reaps the benefits of being the first mover. So as a significant market and a big geopolitical player, the EU tends to set the tone and begins to sketch out how it wants to see regulation. And as it is the first big power to do so, others inevitably will have to follow. And what we have seen with one of the landmark regulations, the General Data Protection Regulation, is that companies sometimes also opt to use the EU's standard, which is often the highest standard in terms of obligations on the part of companies, as the global standard, because then they don't have to fragment all their policies all over the world. They can just use the EU standard, whether it's in, Asia, Africa, Europe, or Latin America. And so we've seen that can be an effect, which indeed Anu Bradford calls the Brussels effect of the General Data Protection Regulation. But there are also a few new initiatives that look at content moderation, the Digital Services Act, and at competition, the Digital Markets Act, and in the pipeline is an AI Act. So the EU is not finished making sure that the responsibilities, liabilities, and obligations of private companies, but also governments, are actually enshrined clearly in terms of what it is they are supposed to do. And because so many of these new laws are either very recent or will still have to be implemented, it's very difficult to conclude definitively what their impact will be. Because the effects still have to be seen, but of course the ambitions are significant. What I will say about the ripple effect that you touched upon in your question is that I think we have to be critical when we hear third countries claiming that they're doing what the EU is doing, because sometimes EU regulation has almost been used as a blueprint. At other times, there have been countries quoting that they're doing what the EU is doing, but they're actually doing something completely different. And they're trying to use the legitimacy and the sort of cover of doing the same as the EU to pretend that what they're doing is legitimate and is within the bounds of the rule of law, while it may not be at all. So I would simply say to those who are worried that there's a kind of copy pasting going on, that the context is always very important. So when the same rule theoretically is applied in a context without safeguards for civil liberties or human rights or due process or an independent judiciary, then we cannot speak of a copying or a comparative situation, even if some of the elements might be taken as inspiration from the EU. So I'll leave it at that as a start. I think there's a lot more to be said about the EU's ambitions and how they play out in the world.
Thank you, and that's really well set up for the rest of the debate. One thing I would like to touch on with you while you're still introducing is also what's the status at the US? What does the split control of Congress mean for tech regulation? Is it really a European story now, or is the US still in the game?
Well, I think it's a very interesting moment in time because the US is catching up, but it's doing so from such a different starting point. I don't know how many of you have seen bits and pieces of another hearing taking place in Congress yesterday, this time with the CEO of TikTok, who I feel like was mainly serving as a representative so that all the members of Congress could reaffirm their opinions. I don't think he was able to persuade anyone, and I don't know if anyone really was persuadable in that hearing. But the point is, it looks very firm. Press has been talking about it for about a week. It was a serious grilling. There was a lot at stake, and it's really being played up, this hearing of another CEO. We've seen the same with Twitter, Facebook, YouTube, Google, and so on. But materially, of course, laws are what matter. And I think it's important that members of Congress remember that those are the most powerful tools they have, not hearings under oath, but really laws on the books. And so the question is really, is the US now finally going to adopt the federal data protection regulation, for example? Because we heard a number of members of Congress saying to the CEO of TikTok yesterday, we are not convinced that you are going to stick to privacy protections for Americans. And I was like, which privacy protections? I mean, there are obviously some commercial consumer privacy protections, but there's not a federal data protection law. And there are a lot of gaps that I think Americans suffer from in the lack of having a more clear law. So the US is catching up, but it's often doing so from a perspective of national security. We saw this yesterday. The driver was not so much privacy protections as a civil right, but more a fear for China, a fear of TikTok being a tool in a geopolitical toolbox. And we've seen that over and over again. So yes, I think, to make a long story short, the US is catching up, but the motive is often national security. And unfortunately, I don't think I have to tell anyone listening to this session, national security has been abused as a reason to push aside checks and balances, push aside democratic principles. And I worry that that could happen again, maybe not under this administration and maybe not as the laws were intended or the interventions, executive orders and so on were intended, but it could easily become a new norm to apply these executive orders top down to intervene, at will, so to say. And of course, there are concerns about, what might be the next administration, what might drive them. And so I think Americans, and especially members of Congress, should be careful with what they wish for. It may look very attractive now to join together Democrats and Republicans to intervene forcefully when it comes to a TikTok or whatever the next concern might be. But the potential risk for the erosion of civil rights and democratic principles, rule of law principles, is significant. And that is what I think should not be forgotten.
Thank you. Let's take privacy, which is one of the frontiers of digital regulation, and come to you, Aisha, because you wrote a brilliant paper in 2021 about the concept of the data subject in privacy law, but through the prism of Afrofuturism. Can you tell us a little bit about your thinking in this area?
Yes, thank you for the question, Kush, and very happy to be here. So the initial idea grew out of a very personal engagement with Afrofuturism, for example, through the literature of Octavia Butler. And I would say that science fiction and articulations of the future are deeply political, because only what can be imagined can also be politically formulated and also politically fought for. So to see it very instrumentally, Afrofuturism provides a kind of counter-future, and the article itself became part of the issue of the feminist data protection, or about feminist data protection, which is open access, by the way. So there are a lot of other great articles to explore. But I took the GDPR, the General Data Protection Regulation, and the formulation of the data subject within as a starting point with my engagement with Afrofuturism. So the data subject is the entity whose personal data is supposed to be protected. And the problem we've been faced with for a while now is that there is really a systemic issue. So there is a disproportionate effect of technological harms on marginalized groups. And there is also a seeming inadequacy of existing regulation to address this, as well as the lack of political will. So focusing on the data subject through the lens of Afrofuturism allows for a couple of observations that I try to outline in an article. So first of all, we need to interrogate who has historically not been seen as part of the subject category, but rather as an object. So Afrofuturism can in part also be seen as a response to the continuous dehumanization attempts that Black people faced. So what exactly happens when we center a subjective experience? And then the second aspect is that the data subject, I would argue, is collective rather than individual. So there's this curious mismatch between the way the data is processed and the way that the protection of it has been individualized in the category of the data subject. And then the third point that really became clear is that the data subject is contextual. That means that there is this paradox of data protection, which is normally thought of as protection of data, but it can also be the protection through data. And many of these insights could be seen in one of the cases I used in order to explore this data subject, this Afrofuturist data subject, which is the German Afro census, which was the first nationwide survey of Black people in Germany and their lived experience. And so, for example, this paradox of data protection, where data protection can sometimes be protection through data, can be seen in the Afro census, where data is really used to make political demands actionable. And in order to make these actionable, we need to collect data on, for example, the experience of racial profiling. So it's a kind of reformulation of what data protection can be. And I think also to bring it to more of a meta level, this article is an engagement with the usefulness of the concept of data protection and maybe the limits of it as a regulatory tool, but also in different ways it can be used. And overarching the question, for whom regulation is made, and what could be ways of constantly refine regulation, to constantly redefine regulation and to kind of adapt the regulation depending on whose voice is finally heard.
Thank you. That's an excellent overview of what is an article I recommend everyone to read. And it's good that we made the point that this isn't assuming that minorities in Europe and in the US are treated well under these regulations. And although we're talking a lot about the global majority, it's important to stress that point as we take this debate forward. And you made that great point about the treatment of Black people in Germany. But moving to the African continent and stressing obviously that it is a continent and as so many diversities within that. What lessons can we draw for applying global tech regulation and particularly data protection on the African continent?
Yes, I mean, I think this links very much to what Marietje said in terms of GDPR as a standard-setting function. So we've seen adoption of GDPR-like regulation in different African countries. And as such, they also are a tool of, I would argue, geopolitical influence. It can be seen as such. So I think it's really important to remember to take into account that regulation is always contextual. And this includes data protection and privacy regulation. And also in the African context, I would argue a focus on the data subject really helps because it asks different questions. So how is the subject impacted by the technology? Does existing regulation cover this? And what kind of lived reality actually forms the basis for regulation? So in the African context, I work together with a colleague of mine, Professor Emmanuel Boama, and this project is still ongoing, and we are looking at the role of financial technology, fintech, in Ghana. And there are really some interesting insights. I mean, it's forthcoming research, but even just I think to problematize the term or to problematize the notion of authority is very interesting. So there's often we look at statutory laws. Some already have colonial legacies in the African context, but then there are also social cultural norms that people abide by, which are not necessarily form a state authority. So really one takeaway from looking into the Ghanaian context is to really take into account people's lived reality, what kind of norms exist in terms of sharing information, what types of cultural practices also exist in encoding information and protecting privacy, and how far these can then influence inform regulation in more local context.
Thank you. And thanks for giving us a sneak peek of that research as well. We look forward to seeing that. And turning to you, Nikhil, and the concept of digital colonialism, which is essentially companies, digital platforms acting in exploiting countries in the same way that imperial powers did a generation ago. But can the power platforms be a double-edged sword in some places? For example, do governments use the narrative of digital colonialism to centralize power? And can platforms actually counterbalance government power in some instances?
Thanks, Chris. So I'll just take off from something that Marietje had spoken about. We in India have a tendency of taking EU laws and making them worse. So we essentially copy-paste portions from EU laws and then sort of modify them to suit the needs to enable a transfer of power. So what we've seen over a period of time is that, prior to the centralization that was brought in with the App Store and the move largely from the web to an app ecosystem, the growth of centralized platforms led to a transfer of powers and negotiating ability from users to the platforms. What's happening in India is that using the trope of digital colonization and the push for sovereignty for India, and I'll talk about some global developments which haven't really helped that cause. We're moving to a situation where there's centralization using digitization and a transfer of power from platforms to the government, instead of, like in the EU, giving that power back to citizens. It's being used by the government to, for example, in India, to regulate speech, to regulate the way e-commerce platforms behave. So bit by bit, we've seen a whittling down of safe harbor. And there's a Digital India Act that's in the works, in which case the minister actually came out in the press conference and asked that, do we need safe harbor at all? Should safe harbor even exist? And so there are, while that is debatable, it's still a worrying sign that we're starting that negotiation with the government on laws related to safe harbor from the point where their starting point is, should safe harbor exist at all? So the idea, India always thinks of itself as the fourth peg, in the sense so there is the EU way of doing things, or the US way of doing things. There's a China way. And India believes that it needs to set its own standard, and there's a fourth way. And for the developing world, India is a critical player. Let's not forget it has the second highest number of internet users in the world after China. So one of the things that we've been hearing about the data protection law in India is that the approach that the Indian government is taking is the not GDPR approach. Rather than copying the EU law, they want to take an adversarial approach to it, to the extent that there are very little rights available to citizens. There are significant restrictions on platforms regarding data collections, but there is a complete lack of accountability for government data collection and for even government entities and the police for data collection. So what we're seeing is a whittling away of rights, away from citizens, and also from platforms, but rather a centralization of power with the government. What's really led to this is, first was, of course, a net neutrality campaign when Facebook was trying to enforce its free basics. I I was a part of that campaign and helped start it. And that's when we heard the issue of digital colonization first prop up. Subsequently, that has been used. I remember a meeting that I was in between the EU representatives and Indian representatives, and there was a sense that India wanted independence in how the payments rails work, because the fear was that Trump and the US were they were shifting away from multilateralism to bilateralism. And what happened with Android in China could happen to countries like India. And if, for example, MasterCard and Visa, which were dominant in payments in India at the time, if Trump woke up on the wrong side of the bed and basically forced MasterCard and Visa to shut the payments rails, the Indian economy would collapse. What we've seen, in fact, so when you look at the Russia-Ukraine situation and how big tech responded to it in terms of shunting Russia out, you look at what happened with SWIFT, right? That forces countries like India to look at another way and to develop sovereign systems. And so therefore we're moving away bit by bit, step by step, from a global internet and to a more local, sovereign and even government-controlled platforms, which is frankly the basis of what India is talking about in the G20 when it comes to the digital public goods. So all of this links together to geopolitics, the push for sovereignty, the pushback against colonization, but also the usage of digitization for centralization of power with the government. And my problem is the effect of that is the fact that it's also removal of power that users have over speech and over privacy.
Thank you. And you mentioned digital public goods. I'd love to go in a bit deeper on that and dig into that. Would you be able to tell us a bit more about what you mean and how that plays into this conversation?
Right. So India's developed a really easy to use payment system called UPI, which is the Unified Universal Payments Interface. And we have, I think, maybe 5 billion transactions a month taking place, and millions and millions of users on the platform. Now, that has been set up through an independent entity with government support, and banks have essentially become a part of it. India is replicating what they did with UPI, and they're trying to replicate it in e-commerce with the setup of something called ONDC, which is supposed to be an independent rails for e-commerce, and unbundling a buyer platform from a seller platform to allow all sellers to participate, and therefore remove the power that big tech firms like an Amazon or a Flipkart, which is owned by Walmart, might have. Similarly, there's a plan for something called a health stack, which is going to be rails for health data and insurance and electronic health records. There's subsequently a plan for an edu stack and a travel stack. So these, even for facial recognition at airports, there's a platform that they've created called Digi Yatra. These are being called digital public goods, but we filed a freedom of information kind of request, which is called Right to Information in India, for details about Digi Yatra, which was doing facial recognition at airports. And the government came back to us and said that they have no data simply because it's not a public entity. And so while these are being called digital public goods, both the UPI, the company that runs the non-profit company that runs UPI, the company that runs Digi Yatra, the company that runs ONDC, which is for e-commerce, are not public entities. They're all private non-profits and therefore not accountable under the Freedom of Information request, not accountable to Parliament. Yet they have the full government support, and they're essentially being used for the government to get control over markets, whether it's payments or it's e-commerce or it's health or it's education, and use those for the deployment of public policy and the dismantling of centralized platforms like MasterCard, Visa, like Amazon. And so it's an interesting experiment. It's only worked once in UPI. They weren't able to roll it out effectively when it came to health, even though they tried during COVID. The big one is e-commerce. But my point is, these are digital. They're goods, sure. They're platforms, but they're not public. And India is now using G20 to try and push this idea of digital public goods, because the world is trying to fight the monopolies that exist in the market. And governments like the idea of control. And if they can control an entire online ecosystem through these networks, that's power that most governments would want to have. Unfortunately, it destroys the market, because if I'm a company in that space, my entire operations are dependent on government policy. So in case of UPI, they moved to a zero MDR, which is merchant discount rate, and completely destroyed the transaction per transaction revenue based business model that those businesses were being run. As a result of that, your only dominant players are PhonePe, which is partly owned by Walmart, and Google Pay. And only those companies that can afford to lose money are now dominating the space. And now they're trying to bring in a regulation or a norm saying that you can't have more than 30% market share in that space, because you've destroyed the market economy in payments then. So it's an interesting battle between, essentially digital monopolies and government so digital oligopolies versus a government monopoly effectively, or a government-backed monopoly.
No, that's very well summarized, and thank you for setting that up for us really well. I want to focus on whether there are any successful examples of ideas in Western digital regulation or concepts being applied well in countries, but in a local context. So taking antitrust, for example, which is the area I specialize in, one of the often cited examples, and it's debatable how successful it is, but it's South Africa, where competition law has a broader range of considerations than just economic efficiency. So it includes the promotion of a more equitable spread of ownership, as well as the interests of workers. So in other words, it's aiming to reverse some of the structural harms which persist as a result of apartheid. But my question is this, and maybe starting with you, Aisha, is this the exception? Are there any examples of how you can apply these concepts and principles in a local context?
Yes, thank you so much. Well, I mean, this is an interesting question, I would say, because there is, in general, I would say it would be maybe misguided to assume that these concepts are inherently European, right? So, for example, privacy is not a Western invention. I think there are articulations of it in regulations that might be Eurocentric and that should be critically assessed, but it does not negate the existence or need for privacy in other contexts. So, for example, some scholars have mentioned that there seems to be this idea that Africans have a privacy myopia, which means that they do not care for privacy or the protection of their data in the same way that, for example, Europeans would do so. And this is obviously not true. But the articulation of privacy can differ. So how the regulation thereof in the context of digital technology needs to be approached could really differ as well. And I think there is careful work to be done in specifying what exactly the specific contexts are. And so I wouldn't a priori say that it would be an application of Western concepts, so to say. I would say in general, there are certain concepts that are universally relevant to consider, at least. And then how they're applied, that's a very different question. But I would say data protection is one of these examples that's very useful in many different contexts.
And Nikhil, would you like to come in on this point?
Could you
Yes,
phrase the question for me, please?
Yeah, of course. What we were talking about was the application of some of these concepts, but in a local context, and are there good examples of that being done? And Aisha made the very good point that they're not necessarily Western concepts. It's just that the regulation has been promulgated, in Europe or in some cases in the US. But I wanted to understand if there were really successful examples. We've talked about some of the failings. I wondered if there were any good examples.
I think one of our successes has been net neutrality, in the sense that until our campaign sort of came to the fore, zero rating wasn't really considered a net neutrality issue. And one of the challenges was, when we were running the campaign, was to convince people that in India, because the cost of data was so high, we really didn't care about whether you'd be, and the speeds of data were so slow that we didn't really care about whether we were getting, the differential speeds for different services. What we cared about was pricing. And so at that point in time, Facebook was zero rating. There were a couple of Indian telecom operators that was zero rating specific apps. And we ran that campaign to try and enforce the point that on the internet, by design, all users are equal. And so therefore, whether it comes to pricing of data services for accessing certain apps or services, and as well as speeds, we need to treat everyone equally. And so just because you're accessing Facebook, it shouldn't be free. And if you're accessing my site, for example, it shouldn't be paid. And that only enhances sort of centralization of power with the platforms. And so we've got the strongest regulations in the world right now on when it comes to net neutrality, specifically on pricing. And even though telecom operators, as they always do, are trying to reverse it, they don't give up. I think that's an example of where we've taken an Indian problem of pricing issues, and and that's now been incorporated into how net neutrality is looked at globally.
Thank you. And you mentioned in the middle speech as well as net neutrality. And Marietje, I'd love to come to you now, and just the fact that the proposed regulations in terms of speech or not regulating speech in the US and in the EU, they take very different approaches. And you've got the Digital Services Act, which you mentioned at the top, versus Section 230, which is currently before the Supreme Court. And I wondered which of those values would be most appropriate for applying regulation in parts of the world. What is the status of that at the moment?
Sorry, what is most appropriate to apply?
The values between the EU versus the US in terms of the approaches to freedom of speech, and how can they be exported?
It's a big question, because I don't think the goal is to export. I think here we actually see real examples of very local context, even if in the broader global context, the US and the EU are very similar, right? They're both liberal democratic blocs. They both have something of a federal system. They're both advanced economies and so on. So I think what we see in the US is the overemphasis on speech has really stifled a lot of other rights and regulatory approaches, because speech is a constitutional right. It's obviously extremely important for human rights more broadly, universal human rights. But in the US context, the way in which regulators have thought about speech, but also tech companies have lobbied around speech protections, it has made it very difficult to, for example, also consider non-discrimination as a vital right that is at stake in the context of social media platforms, or the protection of democratic integrity, or accountability and oversight. I mean, there are so many different aspects that have been snowed under or overshadowed by the overemphasis on speech. And I think there's still a lot of misunderstanding about which kind of speech protections Section 230, but also the First Amendment actually grants. Because there's a significant difference between obligations on the part of governments and obligations on the part of companies. And so that is, I believe, a specifically American issue, which in Europe is seen somewhat differently, in the sense that speech is largely free, but there are exceptions. And there's also consideration for the specific business models of social media companies and how they do not only either share or not share speech, but they also gather data. They micro-target certain speech to certain audiences. And so in Europe, the idea is that if there were restrictions to speech that were in specific contexts already legitimate, for example, Holocaust denial is one that I think a lot of people are aware of. It's not allowed in a number of countries, but also expressions of hate speech and so on, then that should apply online as it does offline. And the most recent law, the Digital Services Act that we briefly spoke about, makes it more clear which specific obligations exist on the part of tech companies. And that dynamic, so to proactively articulate obligations on the part of tech companies, I think is something that can be replicated. But I do not believe that the way in which speech and exceptions to speech protections in the EU are encoded in law are very easy to export, because there are already so many specific contexts globally with regard to how speech is treated. And in fact, in a lot of parts of the world, it's more restricted, or national security measures can easily be invoked to restrict speech ad hoc if a government so chooses. And so what I think is really important to remember when we talk about laws, and what I think gets lost a lot when we talk about tech regulation, is how laws also should protect people from the abuse of power by governments. Nikhil has talked about this a little bit, and that's what I often miss when people talk about exporting laws and so on. It so much depends on how the law is implemented, and when the thought behind the law, which is, as it is in Europe, for example, is to also make sure that people cannot be surveilled by their own governments, because there have been some difficult lessons learned in Germany, in former Soviet-led countries in Europe. So that is a dark page of history that people do not want to see repeated. And so the whole idea behind the law is not so much to chase Silicon Valley companies back into their corners, but really to protect citizens first and foremost from the abuse of power, whether it is by governments or by companies. And I personally wish that that aspect would be exported more, sort of in a legal, philosophical manner, because I miss that dynamic a lot. I hear a lot of Americans, for example, who think that laws in Europe are almost singularly adopted to go after US tech companies. And I'm like, no, it's also about making sure that the government stays out of the lives of people, and that there are consequences when the local municipality doesn't protect the privacy of citizens. And so citizen protection, rights protections, rule of law mechanisms, I believe, are needed in many parts of the world. And so when we think about the applicability of law, let's be sort of clear about the philosophical underpinnings and the value underpinnings that we do and do not want to import, export, adopt, learn from, or be inspired by.
Thank you. And on that note, we have our first question from the audience, which is asking about whether there is any recommended literature for someone wanting to understand global technology use and how it differs between different countries. Aisha, do you have any recommendations here?
I do. There are two readings I would start with, and I excuse my lighting. The sun's coming in. So I think I would start with a book called Technology of the Oppressed by an author called David Niemer, and he looks at the Brazilian favelas. And it's open access as well, so you don't need to pay. But he looks at the favelas and how people are adopting technology, how are they appropriating technology for their own needs, and it's really a fascinating insight, and I think quite a critical view as well that's very much needed. And the second one would be from Paya Laura, who is a professor as well, and she wrote a book called Next Billion Users, which I would also highly recommend.
Thank you for that. That's super interesting. And we had another question about AI and about regulation of AI in India. So, Nikhil, if we start with you, I mean, how does AI play into this? Everyone's talking about it at the moment because of certain products in the market, but what's the long view, and how do you think it's developing in India?
So, one of the things I try and remind everyone is that India went to court to protect the system, arguing that privacy isn't a fundamental right. Our government went to court arguing that privacy isn't a fundamental right. and at the core of that was to build a data economy. So India tries to position itself, and that's the narrative that we are being sold, is that India is a data-rich country. And before being economically rich, we need to be data-rich. So the systems and many of these digital public goods that we discussed, they are essentially built around the idea of collecting more and more data. And the idea is that that data is the fuel of the fourth industrial revolution. And so therefore, the more the data that floats around, leave alone that it is personal information that's floating around, nobody cares. At least the government doesn't care. And so as a result of that, we have a weak data protection law that was the latest draft was extremely weak, not protecting rights. And our data protection law it has two goals. One is to protect citizen privacy. The other is to enable a data economy, which are competing goals. It leans more towards creating a data economy and using. And so even when it comes to AI regulation, what we hear from the government is that they want to take a light touch approach. They don't want to regulate artificial intelligence simply because they want to give India a chance to become an AI superpower. And they believe the more the data there is available, the more, the more the data that can be used to build artificial intelligence systems. And so, this digital public goods approach is exactly based on the same idea. And there is no law, and there is no law planned.
Yes, thank you. And Marietje, just very quickly on the regulation of AI, is it more a race to regulate or an arms race? How do you see it?
Well, I think currently the companies are racing very powerfully. They are convincing governments, for example, in the US, that not intervening is the best way to protect democracy and to keep China at bay. Whereas in Europe, again, a very different approach. There is a recognition that there should be protection against the risks coming out of the uses of AI. And I think what's missing there is a regulation of the AI as such, but that's something we can talk about later. But different applications are considered to be risky, and there should be mitigating measures to try to limit that risk. And I think that if a technology can only be considered successful without regulation, you really have to ask yourself about how successful a company or a technology can really be, because it's completely normal to protect people against harms, to protect the environment, to protect anything from children to consumers to democracy. And so I wish that this whole idea of regulation would be considered as something that's very normal and integral to our free and open societies, and is not some kind of weapon that's used against companies to strangle their beautiful innovation. We really need to understand what regulation means in a different way. And to me, it has always meant protecting the individual or communities, vulnerable groups from the abuse of power by the most powerful, whether those are companies or governments.
Brilliantly explained, thank you. And we're coming towards the end. It's gone very quickly, and I've got so many other questions I would like to ask, and there's questions coming in from the audience as well. But we'll just end with a final question for each of you, which is, what is one thing that the MozFest global community should pay attention to in this race to regulate AI? Aisha, can I start with you?
Yes, you can. I have two, but very quick points. I think one would be that there are many important issues in regulating AI, but I would say pay attention to the material conditions that underpin it. So sometimes we can get caught up in the abstract questions of it, but I think it's also really important to pay attention to some other elements, for example, the annotation work or the cleaning of data sets that's underpinning AI. And where that happens, so amplify the voices of micro workers in Kenya, Madagascar, Venezuela, and all the other places. And the second one, very quickly, I think it relates to that, is there is this notion that we of regulating beyond borders, I think, which we touched upon with GDPR, also applying another context. And I would say pay attention to the border zones. It's not only how regulations apply beyond borders, but what happens in the border zones, because there's a lot of vulnerability created at the moment when it comes to, for example, migrants, and this vulnerability is exploited. So I would say that those are the two fields I would pay attention to.
I'm very glad we let you have two. Nikhil?
I'm going to go and I'm going to talk about something that is something that people don't usually talk about, which is look at how non-personal data is regulated. That's the learning from India. India is trying to say that the data that is collected on communities, aggregate data, belongs to the community, and therefore by extension belongs to the state, and the state can basically force companies to give up what is effectively business intelligence in order to enable an AI economy. That, at least we are seeing that as a destructive move, but watch how anonymized data, non-personal data is regulated in the move to further the cause of artificial intelligence.
And Marietje, final word to you as the only panelist who got a round of applause in the middle of her intervention.
Oh, I did. I didn't even notice. But to the MozFest audience and the Mozilla community, and specifically all of you, I think there's still an incredible need to understand better what AI is and is not. Too much hype is a problem because it justifies all kinds of, room for companies that are going to solve all of the world's problems and therefore need to be left alone. But also when there's hysteria and concern about what AI might mean, there could be a wrong approach, because it could, for example, go after the major risks only, even if there are also more subtle risks or, creeps of privatization of governance as such, privatization of knowledge as such, that nobody would probably identify as a major risk, but that will have extreme consequences for the governability of AI, just to mention one example. And so to the Mozilla community and everyone joining here, I'm going to assume that you have more than average technological knowledge and interest. And so to really help citizens around you understand what AI is and is not will inevitably help and contribute greatly to a better informed public debate, which will then lead to better informed public policy. So be a counterweight to PR speak, to lobby talk, and to unfortunate but understandable misunderstandings about what AI could be. So maybe that could be a practical thing people can contribute to.
Brilliant, thank you. And thank you to all three of you for sharing your insights, expertise, experience, for creating such a rich debate. We could have gone on, I think we barely scratched the surface, but I really appreciate your time. And thank you everyone for watching. This is the last Dialogues and Debates at MozFest, so we hope you enjoyed them. Please keep an eye on social media, at Mozilla Festival on Twitter, where we'll announce future Dialogues and Debates panels. And a special thanks to the production team behind the scenes, and again to our fantastic panelists, all three of you. You're brilliant. Take care, everyone. Thank you.
Thank you.